As we navigate the increasingly complex world of business law, organizations face unprecedented challenges in adapting to new regulations, technologies, and global expectations. The legal landscape is evolving at an accelerated pace, creating both opportunities and risks for companies of all sizes. This presentation examines the key legal challenges businesses will face in 2025 and beyond, highlighting the dramatic shifts driven by technological innovation and regulatory developments that are reshaping corporate legal responsibilities. Our agenda today will cover an overview of trends, technology and data issues, ESG and compliance, and globalization and legal risks. We'll examine the shifting business law landscape and emerging regulatory frameworks impacting corporate operations. We'll also delve into the analysis of legal challenges arising from AI, data protection, cybersecurity, and intellectual property in the digital age. Additionally, we'll explore environmental, social, and governance regulations and their implications for corporate policy and reporting, as well as cross-border compliance challenges. The business law landscape has undergone significant transformation since 2020, with regulatory complexity increasing at an unprecedented rate. Legal frameworks have evolved to address emerging technologies, environmental concerns, and changing social expectations. According to the UK Law Society's 2024 report, business law disputes have risen by 23% compared to 2020 levels. This upward trend reflects the challenges companies face in navigating an increasingly complex regulatory environment while managing the legal implications of digital transformation initiatives. The digital transformation of legal processes has accelerated dramatically, with AI integration now driving contract automation across industries. Legal departments are increasingly relying on technology to manage routine work, freeing human resources for more complex issues. Digital signature adoption has surged by 300% since 2022, fundamentally changing how businesses execute agreements. Meanwhile, algorithmic decision-making and compliance functions is creating new efficiencies, but also raising new legal questions about accountability and transparency. The legal landscape surrounding artificial intelligence is rapidly evolving, with the EU AI Act set for full enforcement by 2026. This landmark legislation creates tiered obligations based on risk categories, affecting how businesses develop and deploy AI systems. Liability for AI-related decisions remains a significant grey area, particularly concerning black box algorithms, where decision-making processes lack transparency. Courts across Europe are now establishing precedents that will shape the future of AI governance and corporate responsibility. GDPR enforcement has intensified, with fines exceeding £2.9 billion in 2023 alone. These penalties have targeted a wide range of violations, from insufficient legal basis for data processing to inadequate security measures. The UK's Data Protection and Digital Information Bill introduces new compliance requirements aimed to reduce administrative burdens. However, cross-border data transfer litigation has increased substantially following key court decisions that invalidated established transfer mechanisms, forcing businesses to implement alternative safeguards. The cybersecurity threat landscape continues to intensify, with 81% of UK organisations suffering at least one successful attack in 2024. This alarming statistic highlights the critical importance of robust incident response planning and implementation. Regulators have established increasingly stringent reporting timelines, with the EU requiring notification within just 24 hours of discovery. Director liability for cybersecurity failures means board members now facing personal legal exposure if they fail to exercise appropriate oversight of company security measures. Global trademark filings increased by 13% in 2024, reflecting the growing importance of brand protection in the digital marketplace. Companies are securing rights across more jurisdictions and new digital categories. Non-fungible tokens and blockchain applications have opened new IP controversies around ownership, copyright and licensing. Courts are establishing precedents that will shape digital asset rights for years to come. The remote work era has created unprecedented challenges for trade secret protection, necessitating sophisticated technical and legal safeguards to maintain confidentiality in virtual environments. ESG regulations continue to expand in scope and stringency. The UK's adoption of Task Force on Climate-Related Financial Disclosures, TCFD standards, has made climate reporting mandatory for large firms, creating new compliance obligations and potential liability. The EU's Corporate Sustainability Due Diligence Directive, CSDDD, extends responsibility through global supply chains, compelling businesses to monitor and address human rights and environmental impacts. Meanwhile, shareholder engagement over ESG disclosures increased by 44% in 2023, signalling a new frontier in corporate legal risk. Supply chain human rights compliance has become a critical business imperative. UK Modern Slavery Act compliance audits have surged as authorities intensify enforcement efforts and expand scrutiny beyond direct operations to extended supply networks. Germany's Supply Chain Act, established in 2020, has one of the most stringent due diligence requirements in Europe. Companies now face significant legal and reputational risks from forced labour allegations, with several high-profile cases demonstrating how such issues can escalate into major corporate crises. The legal landscape surrounding diversity, equity, and inclusion continues to evolve rapidly. Companies must navigate complex and sometimes contradictory requirements while maintaining inclusive workplaces that comply with expanding regulatory frameworks. The FCA now requires listed companies to meet board diversity targets and disclose progress annually. Similar requirements are expanding across jurisdictions, creating new compliance obligations. Employment tribunals involving diversity-related cases have increased 32% year-on-year, with courts often mandating accommodations to make reasonable adjustments. The UK Competition and Markets Authority, CMA, has intensified its focus on technology giants, launching multiple investigations into Google, Meta, and other dominant platforms. These cases examine market power abuse, data advantage exploitation, and anti-competitive practices. Regulatory remedies have included operational restrictions, mandatory interoperability requirements, and significant penalties. The Digital Markets Unit now exercises special oversight powers over designated companies with strategic market status. Merger review timelines have extended significantly, with average review times increasing 40% since 2021. This reflects more complex analysis methodologies and greater scrutiny of proposed transactions. The expansion of extraterritorial legal regimes has created a complex web of overlapping and sometimes conflicting obligations for multinational enterprises. Companies must navigate regulations that extend beyond traditional territorial boundaries, creating compliance challenges across jurisdictions. Anti-corruption enforcement, under the US Foreign Corrupt Practices Act and UK Bribery Act, reached record levels in 2023, with combined cases exceeding £724 million. These cases increasingly target individual executives alongside corporate entities, raising personal liability stakes for leadership operating in high-risk markets. International sanctions regimes have grown increasingly complex, with Russian sanctions alone resulting in £1.8 billion in asset freezes by UK authorities in 2023. These measures create significant compliance burdens for businesses across sectors, with new restrictions on AI systems, advanced semiconductors, and quantum computing. Companies must now implement sophisticated strategies to prevent inadvertent violations that could result in severe penalties and reputational damage. Export controls have tightened for targeted emerging technologies, requiring businesses to adapt quickly to changing regulatory landscapes. Requirements for diversity, independence, and specific expertise have expanded significantly. Regulators now expect boards to include members with climate, cybersecurity, and human rights competencies. The UK High Court's 2024 rulings have broadened the duty of care expected from directors, extending responsibility beyond traditional financial oversight to encompass environmental and social impacts. Directors now face personal liability for errors in non-financial reporting, including sustainability disclosures and modern slavery statements. This represents a significant expansion of individual risk. Dispute resolution methods are evolving, with arbitration and mediation gaining popularity as alternatives to traditional litigation. Arbitration has seen a 27% increase in use since 2022, offering private adjudication and limited appeal options. Mediation, with an 85% success rate, focuses on relationship preservation and non-binding processes. Online dispute resolution is rapidly growing, providing a cost-effective and accessible approach for cross-border disputes. These methods offer businesses flexibility and efficiency in resolving conflicts while minimizing public exposure and legal costs. Consumer protection authorities have intensified scrutiny of environmental marketing claims. The UK Advertising Standards Authority banned 18 green advertisements in 2023 for misleading content, setting precedents for future cases. Class action lawsuits targeting false or exaggerated climate claims have increased substantially. These cases typically allege consumer deception through overstated environmental benefits or unrealistic net zero commitments. Courts are increasingly willing to hold individual directors accountable for corporate greenwashing. Recent cases have established that executives have a duty to ensure the accuracy of public environmental statements. Recent landmark rulings have reshaped the legal landscape. The Schrems II decision by the Court of Justice of the European Union invalidated the EU-US Privacy Shield, causing major disruptions to international data flows. Companies were forced to implement complex alternative transfer mechanisms and seek additional assurances for international data sharing. The CMA versus Meta privacy case imposed unprecedented £50 million fines on Meta in 2024 for alleged privacy breaches that also created competition concerns. The Shell climate ruling set a groundbreaking precedent by ordering Shell to reduce its CO2 emissions by 45% by 2030, thus creating a judicial precedent for more stringent environmental litigation based on Paris Agreement commitments. Looking ahead, companies must adopt proactive strategies for managing legal risks. Emerging technology governance will create unprecedented legal challenges, particularly in cryptography and data security. Companies should establish cross-functional teams to identify regulatory gaps and develop internal governance frameworks before regulations are enforced. Compliance by design integration is essential, embedding compliance requirements throughout the development process. Establishing robust, ongoing legal education for all staff has become essential. These initiatives should focus on practical scenarios for personal responsibility, ensuring preparedness for potential legal challenges. The accelerating pace of legal change requires a proactive approach to business risk management. Companies that anticipate regulatory developments gain competitive advantage through better preparedness and lower compliance costs. Legal teams must shift from reactive problem-solving to strategic risk anticipation, working closely with business units to identify emerging issues before they create significant exposure. Ongoing legal education and adaptation are no longer optional but essential components of corporate resilience. Organizations must develop systems to monitor regulatory changes across all relevant jurisdictions and quickly incorporate these developments into operational adjustments. The most successful companies will be those that view legal compliance not as a burden, but as an opportunity to build trust with customers, employees, and regulators.